Hi everyone, hope all are doing good. So welcome back to the channel. So we are starting with November magazine polity topics. I've missed science and tech and environment topics from the previous magazine, that is October. So I will be uploading those missed topics with the November magazine itself. Okay, now let's continue with the polity topic of November magazine. Before going through this video, keep the magazine with you. Okay, so today I'm teaching with my notes, so you can simultaneously look into your magazine and go through the video, or you can directly do it from my notes, where the description to the notes is attached in the first comment. You can download. Okay, so yeah, let's start with the topic, that is land registration system reforms and conclusive titling. So why was this in news? Because recently Supreme Court's observation in Saimullah was the state of Bihar, there was a renewed push to transition India's land registration from the current deed registration model to conclusive titling system. Okay, why this is happening? To reduce the litigation and fraud. So let's understand what is deed registration and what is title registration, aka torrent system. Okay, let's understand this topic through a story. It's a pretty good example. Okay, so let's consider a person named Ramesh. Okay, Ramesh. What does Ramesh do? Ramesh goes to Suresh and he pays X amount and he purchases a land. Okay, so then Ramesh and Suresh both together go to sub-registrar office and pay stamp duty and get a registered sale deed. Sale deed is nothing but an agreement where all terms and conditions will be written, and it will be having information about the land you have purchased, and it will be having information about whom did you purchase, everything. Okay, that's a sale deed. You can go and search it on Google, you will get an idea. And they pay stamp duty to the sub registrar, they will register in a Ramesh names. Okay, and Ramesh will pay the money to Suresh and he will be happy. What happens? There is a presumptive catch here. After 2 years, Suresh nephew, okay, Suresh nephew comes back. Let us name him Vikas. Okay, so Vikas comes back and he claims that land was ancestral and Suresh had no right to sell it alone. Okay, so basically Vikas is saying that Suresh don't have complete ownership of the land because it was his ancestors, so he also has claim on that land. So this is a legal gap. So what is a legal gap? In India today, if you go to a sub register, so sub register does not guarantee you that the land ownership completely is yours. Okay, so what Vikas can do? Vikas can go to a civil court and put a petition, or uh, put a case on that land, or it may lead to a legal dispute over the land. Okay, so what is a legal gap right now is that the register only says that I witnessed Suresh selling this to Ramesh and he has collected the tax. So basically the registrar is just a witness, okay, is not a guarantor. So what will be the burden? Again, Ramesh must go to the court and prove that the chain of documents showing, or whatever the documents they are there, uh, it belongs to him. Okay, like the chain of documents showing who owned the land and all and everything. The burden is on Ramesh. Okay, so what is the problem in that? So the problem is that there are right now 66% of cases. Okay, there are right now 66% of civil cases stuck in land disputes. Stuck in land disputes. So what happens if a land is stuck in dispute? You can't gain anything from that. You can't do anything from that, and it's like a dead asset. And on that, you are investing money to fight the legal battle in the court. Okay, understood. So this is deed registration. What about the other one? That is title registration or torrent system. Okay, so here the registrar is a king. Okay, under the system, the government maintains a single master ledger. So what is this master ledger? It's nothing but a title register, where when you take a land, it will say that you own the land completely. No one can claim that. Okay, whenever you go to sub register and you register it and buy the land, your name is registered in this register saying that you have complete ownership on the land. Okay, so the guarantee. What is the guarantee? That if Ramesh name is in the ledger, okay, if Ramesh name is in the ledger, the state guarantees. Who is the guarantor? The state. The state guarantees he is the owner. तो शिफ्ट क्या हुआ यहाँ पे? What is the shift? If Vikas after 2 years, okay, if Vikas after 2 years appears suddenly from nowhere, he can't sue Ramesh. Sue का मतलब है वो कोर्ट नहीं जा सकता. So अगर कुछ गड़बड़ है, अगर रमेश ने कुछ गड़बड़ करके रजिस्ट्रेशन कराया है और वो गवर्नमेंट के सामने आता है, ओके, इफ दैट कम्स इन फ्रंट ऑफ द गवर्नमेंट एंड इफ द गवर्नमेंट हैज मेड अ मिस्टेक इन द लेजर, तो गवर्नमेंट क्या करेगा, विकास को कंपनसेट करेगा, ओके, इट विल कंपनसेट विकास एंड देन रमेश डोंट हैव टू फाइट लीगल बैटल, ओके, रमेश को लीगल बैटल भी नहीं करना पड़ेगा, ठीक है। सो द रिजल्ट इज दैट ही कैन Ramesh can get profit from that land or whatever he can earn, or he can invest on that, he can grow, or he can take loan on that, okay, and he can develop that. So litigation भी कम हुआ, litigation reduces and it works final, okay. So that is the concept, okay. I hope you understood it clearly. अगर ठीक से समझ में नहीं आया दोबारा रिप्ले करके देखो, I mean you would get that it's simple, not that much complex, okay. So that is it, the difference between deed and title registration. So static linkage क्या है, फेडरल स्ट्रक्चर है, दैट इज शेड्यूल 7, सॉरी, ओके, फेडरल स्ट्रक्चर शेड्यूल 7, डिस्ट्रीब्यूशन ऑफ लेजिस्लेटिव पावर्स और प्रॉपर्टी लॉस, इंटरप्रिटेशन ऑफ कॉलोनियल स्टैट्यूट्स, ओके, और कोर कॉन्सेप्ट तो मैंने बता दिया है। नेक्स्ट वही लैंड स्टेट सब्जेक्ट में आता है, लैंड इज इन स्टेट लिस्ट एंट्री 18 और रजिस्ट्रेशन ऑफ डीड्स एंड डॉक्यूमेंट्स इज इन कंकरेंट लिस्ट एंट्री 6। कंकरेंट लिस्ट पे जो भी होगा उस पर स्टेट और सेंट्रल दोनों कर सकते हैं। अगर सेंटर और स्टेट का दोनों लॉ कॉन्ट्रडिक्ट कर रहा है तो सेंटर का लॉ प्रिवेल करेगा, ओके, द सेंटर लॉ प्रिवेल्स। नेक्स्ट ट्रांसफर ऑफ प्रॉपर्टी इज ऑल्सो इन कंकरेंट लिस्ट एंट्री 6, okay. So role of sub register has been clearly mentioned in K Gopi versus sub register 2025. And okay, mutation versus registration. So mutation acts an update in revenue records for tax purpose, okay, and registration acts as public notice of a transaction. So registration is nothing but publicly you are notifying people that you have purchased it or you have taken some amount of land by giving some amount of money and paying duties. It doesn't mean that you have control, I mean like anybody can come and say that we have a claim because it was our ancestor property, like that, okay. It doesn't specify or state doesn't guarantee you that you are the complete owner of that, so there may be legal disputes, okay. So mutation is nothing but an revenue record for tax purposes. It's not a document which says that you are the owner, right? So yeah, that's it from this topic. Let's move on to the next one, that is digital personal data protection rules 2025. One more thing in the previous thing is that, yeah, UL pin, that is BU Aadhaar, a 14-digit alphanumeric unique ID for land parcel based on geo coordinates, okay. So yeah, you can, rest of the things you can just go through the magazine. Right now I am teaching you only prelim specific, okay. Okay, let's move to the next topic, that is digital personal data protection rules 2025. So why was this in news is that Ministry of Electronics and Information Technology, that is METI, notified DPDP rules, okay, fully operationalizing DPDP Act 2023. So what are the static linkages here? So fundamental rights, as you know, Article 21, okay, it also has right to privacy as a fundamental right. And judicial doctrine, the famous case, justice case, Puttaswamy versus Union of India 2017, privacy is an intrinsic part of life. Next, legislative powers, that is Schedule 7, Union List, Entry 31 में क्या बोलते हैं, post and telegraph, telephones, wireless, broadcasting and other like forms of communications are in Union List, okay, so they can make the laws. So concept क्या है यहाँ पे, the DPDP framework follows the सरल approach, simple, accessible, rational and actionable law. Or the name itself is implied that it's on digital personal data in India, including offline data that is later digitized and processing outside India if it involves offering goods services to individuals in India. So for example Google, Meta, सब कुछ इंडिया में पब्लिक को ऑफर कर रहे हैं सर्विस, तो उन पे भी अप्लाई होगा, इट विल अप्लाई ऑन देम ऑल्सो. सो की टेकअवेज क्या है, पहले हमें क्या क्या जानना है. डेटा प्रिंसिपल, डेटा प्रिंसिपल क्या होता है, हम और आप लोग, द इंडिविजुअल टू हुम डेटा रिलेट्स, ओके, तो इंडिविजुअल हुम द डेटा रिलेट्स. And who are data fiduciaries? The entity that decides the purpose and means of processing, like Meta, Google and all. और एक आता है consent manager. Who is a consent manager? An Indian based entity, okay, an Indian based entity who is registered with the board to act as a single point of individuals to give, manage and withdraw consent, okay. तो it's like a booth, okay, एक centralized mechanism है जहाँ पे एक individual can manage everything from single point, okay. Next, significant data fiduciaries. SDFs क्या होते हैं? They are notified by the government based, okay, कैसे? Based on volume, sensitivity of data, risk to rights, and impact on national sovereignty or electoral democracy. Okay, they must appoint a data protection officer. It's like an office. Okay. नेक्स्ट राइट्स ऑफ द प्रिंसिपल. सो राइट्स ऑफ द प्रिंसिपल मतलब हमारा राइट्स क्या है एज ए सिटीजन जो हम एक्सेस कर रहे हैं. तो राइट टू एक्सेस, करेक्ट, एरेज, नॉमिनेशन. नॉमिनेशन मतलब अपॉइंटिंग अ रिप्रेजेंटेटिव इन केस ऑफ डेथ और इनकैपेसिटी. और इसमें क्या क्या इंक्लूडेड नहीं है, व्हाट इज नॉट इंक्लूडेड इज द राइट टू पोर्टेबिलिटी, सॉरी, द राइट टू पोर्टेबिलिटी एंड राइट टू बी फॉरगॉटन. ठीक है, दे आर एब्सेंट फ्रॉम द करंट एक्ट. सो राइट टू पोर्टेबिलिटी क्या होता है? ये अलो करता है आपको आपके डेटा एक सर्विस प्रोवाइडर से लेके दूसरी सर्विस प्रोवाइडर को देना. लाइक यू कैन स्विच फ्रॉम वन सर्विस प्रोवाइडर टू अदर सर्विस प्रोवाइडर without any hassle. Okay. For example, if you're using Spotify, you have a certain favorite songs or a favorite playlist, and you took a new iPhone, say iPhone 17 or some latest version, and you downloaded Apple Music, and you want to move your playlist from Spotify to Apple Play. So you can do that without any hassle. Okay. So that is right to portability. And right to be forgotten क्या होता है? If you want to erase your data, or if you want to erase something which you don't want to be it on the social media or internet, then you can do that. So that has been taken, that has not been included in the rules whatever is given. Okay. So why is it removed? So technical feasibilities, like smaller startups, what did they say? That they said that it is an expensive infrastructure for them, for that to build them. Okay, and there will be some trade secrets. Okay, that's a fair argument, but it's not completely fair, right? So what should we think, and what should be our perspective is that, like, the absence of this rule, like right to data portability, is a blow to consumer competition. Okay, like it leads to vendor lock-in, where an user finds it too difficult to leave a platform. So yeah, and another thing is that right to be forgotten. From UPSC perspective, if we see that it's a biggest challenge, here is a conflict between Article 21 and Article 19. Okay, so yeah, that's it. And yeah, okay, that's it. Nothing important in this. So yeah, other things is means related. You can go through it. And next topic is AI and governance guidelines. So the next topic is India AI Governance Guidelines 2025. So why was this in news is that, so in November 2025, the Ministry of Electronics and Information Technology, that is METI, notified India AI Governance Guidelines. Okay. So what is India's focus? Purely innovative focus to a safe and trusted AI regime. Okay. So what is the linkage with the static polity syllabus is that executive and ministry nodal role, that is METI. It's an interministerial coordination, like that thing. And administrative law, sectoral regulation, that is RBI, TRI and SEBI. What are the rights and ethics perspective? Rights, you can see that Article 14, equality versus algorithmic bias, and Article 21, right to privacy, that we saw in the previous topic also. So what is the concept here is that India AI mission is shifting from cautionary restraint to responsible innovation. Okay, and the framework is also built on a risk-based techno-legal approach, meaning governance is embedded directly into the AI's technical architecture. So content watermarking, audit trails. Like in previous magazine also we studied about this thing. What are the rules on the OTT platform? What it should be like that. Okay, you can just revise that and you will understand this topic clearly. Then what are the 7 sutras we are following is trust, people first, innovation, fairness and equity, accountability, understandable, safety, resilience and sustainability. You can also make a mnemonic or something. So what I found is, like, you can remember it by making a mnemonic like pit FOS, pit FOS, P for people, I for innovation, T for trust, F for fairness, accountability, understandability and safety, resilience and sustainability. Okay. Next, what are the institution associated with is it? Like just remember the name, no need to go deep into this because it's prelims oriented. Okay, AI governance group, sorry, AI governance group, AIGG, AI safety institute, AISI, Okay. Next, what are the sectoral regulators? Decentralized enforcement like RBI for fintech AI. Okay. Next, techno-legal tools include C2PA style watermarking for deep fake detection and DEPA data empowerment and protection architecture for training models. Next, liability model. Okay. There is a graded liability system. And yeah, sovereign compute part of India AI mission involves the procurement of 10,000 plus GPUs. Okay, you know that like to operate an AI system or an AI servers, you need GPUs. Okay, so we need that infrastructure first to implement these things. Okay, yeah, that's it. Nothing much in this to explain. Okay, it's just an initiative. What will be the guidelines in that? Nothing more in that. So let's move to the next topic, that is striking down of Tribunal Reforms Act 2021. Okay, so why was this in news? Because Supreme Court struck down key provision of the Tribunal Reforms Act 2021. Okay, let's understand what are tribunals. Okay, tribunals are quasi judicial bodies. क्वाजी जुडिशियल बॉडीज का मतलब है कि ये पार्शियल जुडिशियल बॉडीज है, नॉट कंप्लीटली जुडिशियल. ओके, क्यों लाया गया इनको? टू रिड्यूस द बर्डन ऑफ रेगुलर कोर्ट्स एंड प्रोवाइड टेक्निकल एक्सपर्टीज. ओके, ऑन Parliament has the power to legislate on tribunals under Articles 323A and 323B. But this power is limited by basic structure doctrine. Okay, so let's understand what is the difference between a tribunal and traditional courts. So if we see about origin, it's a part of permanent hierarchy established by constitution. It's created by specific statute bar acts, that is Article 323A and 323B. General jurisdiction can try all suits of a civil or criminal nature unless barred. Specific jurisdiction, like confined to the particular subject matter defined in its parent act. What is the procedure? Bound strictly by Code of Civil Procedure and Indian Evidence Act. अब ये चेंज हो चुका है, इसको BNSS से रिप्लेस कर दो, सॉरी. ओके, and it's not bound by anything. Okay, the act guided by principle of natural justice. Okay, next, composition क्या है? Manned exclusively by judicial officers, that is judge and magistrate. Manned both by judicial member, technical and experts. Independent of executive influence is higher because parliament has some power on this, it can legislate on that. Decision type, issues a judgment, decree or sentence, issues an award or order. Next, fixed according to court fee acts, this is nominal fee. Okay, so it passes an order. Okay, it is a judgment and decree. There is a lot of difference between an award or order and a judgment and a decree. Okay, so keep these differences in mind. So yeah, so what trap can be set in this is Article 323A versus 323B. So what does Article 323A says? That it's only for administrative matters, that is public services. Only Parliament can establish them. There is no hierarchy. Whereas Article 323B is for the matters of tax, labor, foreign exchange, etc. Both Parliament and state legislature can establish them. Hierarchy can be created. Okay, this is the main difference you should know. And powers of civil court. While tribunals are not bound by BNSS, they are still vested with certain trappings of a court, such as power to summon witness, require discovery of documents, and receive evidence or affidavits. Okay, yeah, that's it about the tribunals. This was the main concept here. Okay, what is the static linkages? As you know, constitutional framework, separation of powers, judicial independence, and judicial review. Next, part 14A of the Constitution, Article 323A, that we saw what is the difference between 23A and 23B, and parliamentary powers, scope of the legislature to nullify judicial directions. Okay, and yeah, you can see there is a legislative overlap, and there is a National Tribunal Commission. Okay, what does it do? It is a permanent independent body to manage appointments, administration, and infrastructure. Okay, next, a legislative override trap that we saw. Parliament can cure the basis of a judgment by changing the law. Okay, but it cannot simply override a judicial direction. Next, yeah, here we have a difference table given in the magazine, that is the Tribunal Reforms Act 2021. What was hit is that the tenure and age limit was 4 years and 50 years, and what SC judgment has done is that the tenure has been increased by 1 year, that is minimum 5 years. Okay, and age limit is 50-year minimum age is struck down. Advocates with 10 years of experience are eligible. Okay, next, the selection, only one name should be recommended by the SC. Okay, for each vacancies to prevent executive cherry picking. Okay, cherry picking means favoritism, like whoever they wish to select, they can't select them. Okay, to avoid this, only one name should be recommended. Okay. Next, yeah, that's it from the topic. Next, we have 30 years of Legal Service Authorities Act, that is NALSA. So why was this in news? Is that it was a 30th anniversary of implementation of Legal Service Authorities Act 1987. Okay, what is the static linkage? We go back to DPSP, Article 39A, that is free legal aid, and fundamental rights, that is Article 14, equality, and Article 21, right to life and privacy, and Article 22, Clause 1, that is right of arrested persons. And another thing is judiciary and area, that is alternative dispute resolution, Lok Adalats. So yeah, what is NALSA? That is Act of 1987 established nationwide network, free and competent legal service to weaker section. Okay. And it gives statutory status to Lok Adalats, whose awards are equivalent to civil court decree. So who are all eligible? Okay, regardless of their income: women and children, members of SC and ST, victims of trafficking, bar beggar, disabled persons, mentally ill, industrial workmen, person in custody. Okay, these are all eligible for free legal aid. Next, there is an income threshold that is recently updated. Supreme Court annual income less than 5 lakh can avail this, irrespective of the categories. And other courts, it varies by state. For example, 3 lakh in Delhi, Maharashtra, UP 1 lakh in others. And Lok Adalats. So what are Lok Adalats? It's given a statutory status. They can settle both pending and pre-litigation cases, and the award is binding. There is no appeal. Award is binding in the sense is whatever the लोक अदालत give, मतलब जो भी लोक अदालत का वर्डिक्ट होता है वो बाइंडिंग होता है. उस वर्डिक्ट को लेके आप हायर कोर्ट्स में अपील नहीं कर सकते उस वर्डिक्ट के ऊपर. ठीक है, सो इट इज बाइंडिंग, इट कांट बी अपील्ड एनीवेयर. बट आप नया पिटीशन डाल सकते हो हायर कोर्ट में जाके. ठीक है, लेकिन उस वर्डिक्ट को लेके हायर कोर्ट में जाके ये नहीं बोल सकते कि हाँ वो कोर्ट ने गलत दिया, ये नहीं कर सकते. यू कैन जस्ट अपील और यू कैन file a petition freshly, but you can't appeal based on this decision or judgment. Okay, I hope you got that. Next, jurisdiction क्या है? Cannot handle non-compoundable offense. Non-compoundable offense मतलब serious offenses. Okay, so yeah, comment करो non-compoundable offenses क्या है. ठीक है. Next, yeah, let's look at how Lok Adalat works actually. So think there is a case entry. दो रास्ते हो सकते हैं. एक रास्ता, अगर कोर्ट के सामने, हायर कोर्ट के सामने कोई पेंडिंग केस है, इफ देयर इज अ पेंडिंग केस, अ केस ऑलरेडी बिफोर अ रेगुलर कोर्ट, सिविल, क्रिमिनल, कंपाउंडेबल और रेवेन्यू. और दूसरा रूट है प्री लिटिगेशन, मतलब कोर्ट जाने से पहले, अ डिस्प्यूट दैट हैजंट रीच्ड कोर्ट एट. एग्जांपल, इलेक्ट्रिसिटी बिल डिस्प्यूट, बैंक रिकवरी, ट्रैफिक चार्जेस, एक्सेट्रा एक्सेट्रा. क्या होता है? रेफरल टू लोक अदालत. अगर बोथ पार्टी अग्री करते हैं तो लोक अदालत को रेफर करते हैं. ओके, और कोर्ट का सो मोटो भी होता है दैट ऑन इट्स ओन इट कंसिडर इट अप्रोप्रिएट तो ट्रांसफर कर देती. नेक्स्ट क्या होता है? लोक अदालत का एक बेंच होता है. इट कंसिस्ट ऑफ ए बेंच ऑफ जुडिशियल मेंबर्स सिटिंग और रिटायर्ड एंड अदर मेंबर्स. और डिफरेंस ये है, यहाँ पे दे एक्ट एज कंसिलिएटर्स. लाइक दे सिट विथ यू, दे विल गाइड यू एंड दे एक्ट एज अ कंसिलिएटर्स, नॉट एज अ जज जो जज करेंगे बेस्ड ऑन द फैक्ट्स. ओके, एंड इट्स गाइडेड बाय नेचुरल जस्टिस, नॉट BNSS. Okay, and it's a zero cost, no court fees. If a court fee was already paid, it is refunded upon the settlement. Okay, outcome क्या है कि scenario settlement reached and award is passed, and scenario 2 settlement नहीं हुआ, the case is sent back to the original court or the parties are advised to seek legal remedies. Okay, the lok adalat cannot decide the case on merits if parties disagree. Okay, ठीक है, समझ आया? तो लोक अदालत कैन नॉट डिसाइड द केस ऑन मेरिट्स इफ पार्टीज डिसएग्री. अगर पार्टी डिसएग्री करते हैं तो लोक अदालत में कोई मेरिट के बेसिस नहीं होता है. ठीक है, कैन नॉट डिसाइड. और UPSC का ट्रैप्स क्या क्या हो सकता है कि लीगल स्टेट ऑफ द अवार्ड, लोक अदालत इज डीम्ड डिक्री ऑफ सिविल कोर्ट. ओके, एंड इट्स फाइनल एंड बाइंडिंग, जैसे हमने डिस्कस किया था. और नो अपील, वो तो पता है. नेक्स्ट, जुडिस्ट्रिक्शन लिमिट्स होते हैं तो अ नॉन कंपाउंडेबल ऑफेंस, क्राइम्स वेयर अ कॉम्प्रोमाइज इज लीगली फॉरबिडन. ओके, एंड हाँ, वन मोर थिंग, परमानेंट लोक अदालत PLS क्या होते हैं? दे आर अंडर 2002 अमेंडमेंट. PLS वेर क्रिएटेड फॉर पब्लिक यूटिलिटी सर्विसेज लाइक पावर, वाटर, ट्रांसपोर्ट, इनके लिए. डिफरेंस क्या है? अनलाइक नॉर्मल लोक अदालत, PLA कैन डिसाइड अ केस on its own merit even if the parties don't reach a compromise, only up to certain of 1 crore rupees. Okay, and yeah, that's it about the topics. And the notes or the news in shorts, we have planned to give it in YouTube shorts. Okay, we will try it and post a short daily on the news in short section, so you can go through that. And yeah, thank you. Let's meet in the next video.